Hello. What is defamation? That's the very first question, because nowadays there is a lot of information, there are a lot of rumors, there are a lot of opinions, either published or communicated more or less privately through some electronic means, emails, text messages, Facebook, other social networks, for chats, whatever. Of course, newspapers, TV channels, radio broadcasts, a lot. So when exactly should you feel offended, or when you feel offended, should you act about that, or when you should just let it go? That's basically the question about defamation in legal terms. So what should we think of when we think of defamation in legal terms, at least in Quebec? In Quebec, in the Civil Code of Quebec, in the Quebec Charter, there is no source of litigation which is called defamation. We speak usually about damage to reputation and dignity, according to the Civil Code, according to the Quebec Charter. And of course, there is always another value to be balanced against. It's freedom of speech. So, as you know, freedom of speech is not absolute, but the right for dignity and reputation is not absolute either. And the idea always for the judge, for the court, is to find a good balance between the two when it happens. So basically, it's not enough to show that you felt offended because of some word of some person published or spoken in rather private situation, like some cocktail party or maybe just a party or whatever. But anyways, at first, whatever is said or published should be seen as attack on your reputation, dignity, honor, maybe yours personally, or some group you belong to, or some organization you belong to. And whatever is said or published should be seen as stirring like bad emotions, bad feeling, bad attitude about you or the organization or the group. Because if, as the result of that bad mouthing, people would feel sorry about you, feel sympathetic to you, compassionate, so there is no actual damage to your reputation and dignity, then it's hard to talk about defamation. Also, it's not necessarily a lie, because when somebody is bringing up some mockery or some hatred speech or disgust, as the court said, against you, it's not always a lie in a sense that somebody would see it as information to believe or not believe into. It's more about expression of emotions towards you, which still can damage your reputation and dignity. So the common view of defamation as of some lies spread about somebody is not exactly what we think of when we speak of defamation according to the Civil Code of Quebec and Quebec Charter. It's more than that, though intentional lies spread specifically to damage reputation and dignity also falls within the meaning of this word when we and if we go to court. Second, and very important, as you definitely understand, many people have a tendency to feel offended, like in a rather exaggerated way. It might be personal, it might be situational, it might be because of the words were spoken by a specific person, a person of authority or particularly respected, or on the contrary, that person is known as particularly hostile towards you. and it's significantly sensible. Maybe it's a context of divorce, for example, or litigation about child custody, where people are very sensitive, or maybe just about some succession, estate settlement, so on and so on. Or maybe it's just a long story of family relationship where wherever even the smallest move made can be seen as something offensive. So the idea is that whatever you think was offensive, it should be equally seen as offensive by uninterested people when they think of them being in a similar situation, or when they just observe the situation from aside. So basically, the idea is to show to the court, to the judge, that the information spread about you was objectively, like really offensive, not only in your own eyes. And if you cannot show that, if, for example, somebody would speak of your, I don't know, fashion style, and if you just overreact to that, there is a possibility that the judge would not see it the same way. And usually when we say objective test and we say the reasonable person in the same circumstances, like in reality, we mean that if the judge, who is a reasonable person, like by default, would see it as offensive or not. Also, there might be a situation when something which would be otherwise offensive would not be in your situation, because your previous acts, your behavior, would justify those words as not like mockery or attack on your reputation and dignity, but just stating the facts, because your reputation and dignity were already damaged before by somebody else or by your own acts again. And then when these particular words said but didn't add anything to the damage, or said or published, didn't add anything to the damage to your reputation, to your dignity again, it again might not be seen as defamation. So as you see, it depends. It depends on the context, it depends on particular perception, it depends on the history of the situation, it depends on like rational view, and so on and so on. Again, simply being offended, simply feeling offended, even strongly, gravely offended, is not enough. To make that damage to your reputation, dignity, honor, those words, this information, those rumors, those opinions should be spread, and not somewhere, but where they might actually damage your reputation. Because, for example, you are a renowned plumber in, I don't know, like West Island, for example, and the information really bad about your plumbing skills is spread somewhere in Australia, let's put it this way, where you have no business partners, no clients, no employers or employees, where basically nobody knows you and nobody knows where to find you even. Nobody knows who you are. Then even widely spread this information would not exactly, as long as it doesn't come back to Canada, it's not like any kind of damage to your reputation where you actually are. And then if you start stirring the situation, bringing up all those allegations, and people in your immediate environment would know about that, they would know about that because of you and your own actions. And then again, you would be seen as a part, at least, of all this campaign of defamation, or maybe even as a source, because before nobody knew where your reputation actually was established. So you see, there are points here. It's not that straightforward. When something is said in strict private situations, like one-on-one, so there is no further spread, it might be offensive, still not defamation. On the contrary, something which is not said publicly, but in a circle, again, of people, where your reputation is established and might be damaged, even if it's, for example, somebody's birthday party, it might be seen as defamation. Maybe an email sent to 1235 addressees, but who know you and who would be maybe not very much pleased to know some facts about you, and whose attitude towards you might change because of that, there we might speak of a defamation. Again, in every situation, you'll need to find proof that words were said, information was spread, really touched those people where your reputation lies, and that reputation was changed, and changed because of that particular behavior, or those particular words and that particular information, and that damage was really done, so it could be measured somehow to be presented in court, and then, yes, there might be a case in defamation. Very important that people not only hear that somebody is spreading bad words about you, it's important that people would consider those words in the sense that they would change how they see you, and what do they think of you, and how to behave towards you because of that. And it's not often easy to prove. There are known situations, known decisions, where the court was seeing some ridiculously bad rumors, opinions, statements as not defamatory because no reasonable person would believe. So, to sum up, there should be some bad information spread about you. This information should attack your reputation, your dignity, your honor, in the way that it was not attacked before, in the way that it was not already damaged before, so that there would be some actual damage done and proven. It should be spread where your reputation, dignity, and honor actually lies, so that it would affect you, really. And it should be reasonably, from an independent point of view, offensive and believable, so that the court would see that, okay, it was not some just, drunk shouting on the street. It was specifically aimed at your reputation. It really damaged your reputation, and you really suffer because of that damage to your reputation. Again, being simply offended is not enough. Why do I repeat that this often? Because, well, I saw quite a lot of situations when people came to a lawyer saying that, you see, there is a publication, there is a publication, there is a publication. That bad person specifically did that to really make me feel bad, and I want to retribute. And as you know, litigation is costly, might be long, and more importantly, it might be seen as nothing really bad was done to you until you started the litigation. and then you brought it up, and then you spread it information, and then you just made it worse and worse and worse. So actually you would become responsible for all or much of the damage. As usual, before you start suing somebody for whatever in court, it's important to distinguish your feelings and your reality from the legal reality, proven facts, and applicable rules. But if you see it as your case, then of course you can sue for defamation. Thank you, and see you next time.